Hello everybody and welcome to this week's episode of Activist Lawyer. I am delighted to be joined by Owen Beattie Solicitor. Hi Owen.
Hey, good morning, how are you?
I am good, and you are in the studio. We love when people manage to make the trip to our lovely studio in Newry.
Thank you.
On this fine Friday, fine October themed Friday. Yeah, it's wet. It's always like that. We're not giving a good impression of our studio when it's always wet every Friday when somebody comes in here. But again, thank you very much for making this journey. Just by way of introduction, we're delighted to have Owen on today because he has just very, very recently established his own practice in Belfast, September this year.
It is indeed.
So
5th of September.
What?
Very recent, very new.
So new. Okay, so Owen will have lots of tips and lots of advice for people who may be interested in getting into that area. Okay, so Owen Beattie and Co-Solicitors was founded, as I said, and established in September 2022. And in founding Owen Beattie and Co-Solicitors, Owen identified the need for a modern, client-centred law firm in Northern Ireland. It's a law firm where clients are the centre of business, and a law firm where clients are provided with straightforward, honest legal advice to secure the best outcome for them. So a little bit about Owen. He qualified from Queen's University and undertook his apprenticeship in a leading human rights law firm in Belfast, where he quickly became an established and recognised solicitor specialising in the area of litigation. Owen has been instructed in some of the most high-profile and serious cases and has represented clients before all court tiers in this jurisdiction. Owen has forged a unique specialism in the representation of clients in all areas of personal injury litigation, and he is regularly instructed in challenges against decisions made by government bodies by judicial review, and equally Owen has a burgeoning reputation in the representation of clients under criminal investigation for offences such as white-collar crime, fraud, sexual offences and other serious crime. Owen is a member of the Law Society of Northern Ireland and has delivered talks to other legal colleagues on best practice in the areas of historical abuse litigation. He's also committed to engagement in the community, working with schools and charitable organisations, which we will be keen to find out more about. So again, thank you so much, Owen. So let's take us back in time a little bit. Law. What made you think of it? Because you're heavily invested now.
I am indeed. So firstly, thank you very much for having me.
You're welcome.
Great to be here. I suppose by way of background, I completed my A-levels in Lismore Comprehensive in Craigavon and thought, well, law can be very often a platform to other careers and other avenues in life. So I picked law with politics, where I went to Queen's University, as I said, and completed a degree in law and politics. And really, while I was there in my first year, I was very fortunate to be offered the opportunity of work experience in a leading human rights law firm in Belfast. And I had completed 1 week there in their criminal magistrates department. And that really involved attending court and attending counsel and going to the police station, which I thought was great, and getting the front line experience, if you will. And really what happened after the first week, the firm offered, if I wanted to come back 1 day a week during the course of my degree and work in the office within the criminal department. And of course, having had a great first week and being exposed to the coalface of the criminal process and representation of clients, I thought, well, certainly, why wouldn't I avail of this? So over a period of about 3 years, I had worked within their criminal department 1 day a week alongside my degree. And again, that ran from attending court and attending counsel to preparing briefs and being very much hands-on in terms of the processes of criminal cases. And I think really that's where my flavour and interest and maybe dedication, I suppose, to this area of work really started to grow and flourish. And I suppose in third year I had considered the idea of the institute and going on to practice as a solicitor. And thankfully and somehow I had passed the exam and got into the institute. And again, that same firm, a leading human rights law firm in Belfast, had offered me my training contract.
Excellent.
So there was really a natural progression, if you will, from doing work experience over a period of 3 years into your apprenticeship and training contract, if you will. So I started my training contract predominantly within criminal defence and magistrates work, Crown Court work, representing clients who had been charged with offences from theft right to very, very serious crime offences. And it was really an unrivalled exposure to criminal defence litigation. And you were seeing cases from the initial point of arrest right through to Magistrates, Crown Court, Court of Appeal, and the firm had unrivalled expertise in that particular area. And as my apprenticeship went on, my work started to vary and expand. So it evolved really from criminal defence into prisoner rights, and being involved in the representation of prisoners in McGabry and Hydebank and McGilligan, and really at first instance dealing with their welfare issues, may that be internal disciplinaries, access to services, and again there was a natural evolution from that into parole applications and representation of prisoners before review panels. And the prison environment is really one in which you obviously are representing clients who may be charged with criminal offences,
Sure.
And they obviously have welfare issues and prison rights. But again, it would be an area in which there can be challenges by way of judicial review, challenges against decisions of the Northern Ireland Prison Service. And really there was, again, an evolution of where my career was going at that time, because the prison environment was, thankfully, and I was very grateful for the opportunity to do litigation, judicial review litigation, representation in criminal cases, and obviously there was at that time personal injury work that would arise within the prison setting. So really in terms of, there was a evolution into prisoner rights, and that's probably about my first year of my apprenticeship. And then more towards the second year of my apprenticeship or training contract, I had started to move into more litigation, while still retaining my DNA, if you will, of criminal defence and representation of prisoners. I had started to practice and train within county court litigation, which really involved a whole variety, a whole vast array of work. So it could have been a road traffic accident, it could have been a protection from a harassment injunction, it could have been a claim against a garage who sold a car that maybe wasn't as
very varied.
Very varied. But again, there was a diverse plethora of work to be in, and again, I was very grateful for all those opportunities, and it was just very lucky at the time. There was an evolution from my initial criminal practice through to prisoners and into the county court. And again, that gave me a wide-ranging and vast experience in a number of different areas of law. And thankfully, coupled with that, and in due course, there was a graduation, if you will, through to high court litigation, and representing clients in various high court actions against various entities. But throughout that, I had thankfully retained a varied practice, but again, sort of confined to a couple of different areas. But it was very much an incremental development. But again, the firm were very much nurturing of that and supportive of my development in those areas. And again, it was a great environment to learn, and you were grateful for the opportunity to handle cases and act in cases with counsel and very experienced solicitors and partners who were cases that were very high profile, but extremely, extremely interesting.
Yeah, really, really vast, as you say, and wide-ranging, kind of a real hands-on apprenticeship, which isn't what everybody, ends up with. So you can see your natural progression there, but always tied back into, your initial practice there in criminal. So hands-on, and you remained there with that practice for some time. Yeah. When did you think or, maybe contemplate setting up by yourself? Because, it's a scary process, I'm sure, but maybe it wasn't for you. So maybe share a little bit about your thoughts around that.
I suppose a very daunting decision, and I'm quite upfront about that, and a difficult decision to make. I suppose from even my early days, I had thought about, the aspirations of partnership and being a director and all that goes with that. But I think within my own view on practice, I was very much tailored to a client-centred approach to how a law firm should run. And the law firm in which I worked was an excellent law firm. very, very experienced and a huge amount of client care and engagement with that. But again, I wanted maybe to do my own thing, which many practitioners have done and have opened their own firm. But I wanted to tailor what I was doing. So, the firm which I now own, we are very set in what we do.
Yeah.
But we specialise in that, and everything that we do is client-centred and client-informed. And that is something that I really wanted to do in terms of running my firm. But the decision is not taken lightly to open your own firm.
No, I'd imagine.
There are 101 implications and things to think about, of course. But I suppose maybe towards the middle of this year, I was thinking, maybe I could open my own practice.
Yeah.
And make the jump, make a leap of faith, maybe.
You went for it.
I went for it, and I am glad I done it.
Good.
I genuinely am. Don't get me wrong, and I'm very candid about this. There are days that you think, oh, this is a bit difficult, or there's troubles ahead, there's choppy waters. But I suppose if you take a pragmatic view on it, you're going to get that everywhere.
Yeah, absolutely.
And you're going to face difficult days in terms of not just looking after your clients, but you're now responsible for looking after a business and colleagues that I work with. And the day-to-day run of a business. So you're not just Mr. Lawyer anymore, you have to put the business head on.
You've all of those hats on. And I wonder, do you think people who are contemplating setting up or have set up recently their own practices, are we moving into more niche, specialised areas of law? Because the traditional model of a general practitioner, a high street setup, specialising in everything, seems to be quite redundant now. Would I be right in saying that? And do you think it's better to really, focus on the areas that you are an expert in and that you can provide that niche tailored advice? Yeah,
so I think you're 100% right in that. In my view, rightly or wrongly, I'm of the view that the day of the high street law firm that does everything and anything, from wills and probate right through to conveyancing and criminal. I'm of the view that those days are ultimately will come to an end, and where your client will want to avail of someone who is specialised in the particular area in which they need assistance. And that is why the way in which we have established, Owen Beattie & Co., we know what we do, we know how do we do it well. And our clients come to us for that unique and specialised experience that we have in those particular areas. But I think that the days of firms having 101 departments that does everything, I don't think that's going to be the future. Absolutely. And even when you look at the way in which firms operate, even across Northern England and Wales, you can see a downturn in relation to the typical high street law firm. And I think incrementally that's moving across here as well. So I think, again, to do your best by your client, you know what you're good at as a lawyer and as a practitioner, and I think by tailoring your services, you then provide a better service for your client, and you look after them in the long term.
And would that really inform, I guess, the makeup of your firm being a modern client-centred law, having that approach, is key to the finding of your firm. And just on that, so it's very clear that your experience, your apprenticeship, your previous work experience with your firm has really informed, the areas that you are now an expert in and that you continue to practice in. What are you specialising in at the moment, or are there any kind of core areas that we could look at?
In terms of the areas that the firm covers, in terms of litigation, so all aspects of personal injury litigation, may that be from road traffic accidents right through to actions for historical abuse victims, actions against police and other government departments. So litigation, really, personal injury litigation in all the forms that it does take. We also represent applicants in judicial review challenges against decisions made by government, and again that can go from prisoner rights right through to challenges for clients who are subject to investigation by police. Again, I have retained a criminal defence portfolio of work where we would represent clients who are arrested and detained for questioning throughout police stations in Northern Ireland in this jurisdiction, right through to the court process, and we represent clients before all court tiers in this jurisdiction. So we do have a portfolio of work, but we know what we do, and we know that the areas that we take on, and that's why we have tailored the approach so that we can look after our clients to the best of our ability.
Brilliant. And I know, and I actually took part in one of your training sessions as well around HIA redress. That forms, you know, a large part of your work, and you have considerable experience working in that. You've had quite a lot of success around that too. And
that's very, very kind of you to say that,
well,
actually.
it's a tough area, I'd imagine. You know, so how's that going? Is that something that's continuing?
Yeah,
or
that's something very much has thankfully remains part of our business model. The representation of victims and survivors of historical abuse, and again that takes a number of different forms in the practice. And I think that we have to remember that when you are representing victims of abuse, you're not dealing with your straightforward road traffic accident. Not to downplay, you know, that area of litigation, or slips or trips, but you're dealing with inherently difficult and sensitive topics for anybody to discuss. And very often, and speaking from experience, the client who entrusts you with that case, you may only be the second or third person that they've spoken to around their experiences, may that be in a children's home, or where the abuse may have taken in a school. So in terms of that litigation, if you will, there are a number of different angles to it. I suppose one, and the most widely known, is the HIA redress scheme, which is the application on behalf of clients to the scheme for compensation. And really that involves consulting with victim or survivor of abuse, you know, relaying from them their experiences, committing that to writing on their behalf, and then maybe commissioning medical evidence and sending that to the Redress Board, who really assess that evidence and then determine, you know, compensation on foot of that. And again, that scheme was really born of the 2015 Heart Inquiry, which so many of our clients had taken part in. And one of the recommendations from that inquiry was this redress scheme. Equally, the representation of victims and survivors of abuse is not just confined to the redress scheme. There is ongoing High Court litigation. Really for two reasons, because one, there are some applicants who, due to where their abuse took place, maybe in a school, for example, does not fall within the eligibility for the redress scheme, so they have to proceed by way of traditional litigation. But secondly, some of the cases are so grave in terms of the circumstances, the only venue to properly secure compensation for your client is by way of the High Court litigation process. But again, that is litigation that is client-centred. I know that's easy for me to say that sitting here and trying to say that, but what you have to remember is the very sensitive and difficult topics that you are discussing with clients in that particular sphere. And I suppose thirdly, within that area of historical abuse litigation is the representation of clients in judicial review proceedings. There have been a number of groundbreaking judicial reviews taken against decisions of government and decisions of the HIA Redress Board, which I was involved in. So again, it's deploying not just the traditional personal injury litigation model, it's being live to that judicial review is available to challenge decisions on behalf of victims and survivors of abuse. So that is something that is a huge part of our business, and we're very grateful for those instructions and to be trusted with those instructions because it is obviously very sensitive, but it is something, thankfully, that throughout my apprenticeship and my former employment and in my new practice, that has continued to grow, thank goodness.
No, that's fantastic. And then you've had a number of high-profile cases as well. One in particular stood out against a social media giant, namely Facebook. How did that come about, and you were successful in that case as well?
So that case involved the representation of a journalist and political commentator, and effectively he had a number of Facebook pages which he would have used to publish and to express his views in relation to political and religious matters. And he had thousands of followers, not just in Northern Ireland, but throughout the world. And Facebook had taken the decision at the time to effectively pull the shutters down and shut down his Facebook platforms. And obviously this had a detrimental impact for our client, and he had a large number of followers, as I've said, who were equally not as happy. So we had been instructed, thankfully, to take an action against Facebook, and it was one of the first actions of this nature, I understand, to be taken against Facebook. And it was really a number of elements to it. There was a personal injury element to the case where the client had suffered as a result of Facebook's actions, but there were also niche and very boutique areas of law of data protection, and his Article 8 rights of the Convention were engaged, and his Article 2 rights. So it was the first case that really, in our view, had brought together various elements of your traditional litigation model, but were combined with data protection and convention rights. And thankfully that case resolved on favourable terms for our client. It was a confidential basis, but it was resolved on very favourable terms for him.
Excellent.
And again, one of the very first cases of that nature to be taken.
Wow. Yeah, and I'd say not an easy one at that. So obviously, a lot of your work is carried through, and you've very interesting cases and niche cases that you mentioned there, and you can see how passionate you are about both the clients and the outcome there, which is fantastic. But just in terms of some of the criminal matters that are ongoing and, actions against the police, I know that still forms a major part of your work. What specific issues perhaps are coming up in that regard?
I suppose criminal litigation, in terms of defence litigation, can bleed into other parts of your practice. And the representation of a client under criminal investigation gives you the experience of knowing and understanding how police operate an investigation against a client. And equally, you have the experience of how they're meant to operate when dealing with the victim of an investigation. So it's that experience from our criminal work which flows into our litigation against police and other state agencies. And as recent as Monday of this week, we had a case settled, again on favourable terms, thank goodness, against the Chief Constable.
Okay.
And that case, again, it was a very difficult case in the sense that I was representing a lady who made complaints of a sexual nature to police, very, very grave context. She put her trust in police to investigate those alleged crimes, and it transpired that police did not. And that's not just me saying that. The police ombudsman at the time had conducted a very thorough investigation in relation to the alleged failings made by our client, and he had upheld our client's complaint. From that favourable complaint by the ombudsman, we had lodged High Court proceedings against the Chief Constable in relation to an alleged breach of her human rights under the Convention, Article 3, together with alleged failings, we say, of misconduct and the failure to follow reasonable lines of inquiry. That case was listed for trial on Monday of this week and was due to run for 3 days, full contested hearing in the High Court, senior counsel instructed, ready to go, and the case ultimately settled on Monday of this week, and a very favourable outcome for our client. Obviously, as I've said, hugely difficult subject, and very both personally and the emotions that are at play there, but to commend our client for bringing the case and standing up for what she knew at the time was right, and an absolute credit to her, and to bring the case as far as a contested trial before the High Court and going through the various litigation stage is not easy at the best of times. But when you're dealing with the state and actions such as this, it heightens not just emotions but the difficulties of these cases. So the case had resolved on Monday of this week in our client's favour. At the same time, there are a number of these cases that remain ongoing. The traditional view of criminal law is that it can only be deployed to represent clients who are subject to investigation. It is also there to help and assist victims and complainants in investigations, and very often that is something that is not recognised or seen. So it's all about really trying to use your experience from other areas and deploy it to assist your client as best as you can. And again, a similar example would be an ongoing High Court judicial review against the Chief Constable for our client, who is a witness. Again, a different scenario. She is a witness to a criminal investigation, and the police have seized and detained her mobile phone. and we have an ongoing judicial review in relation to her data protection rights as a witness during the course of a police investigation. Again, a very unique area, and something that I don't think has been done here before. So we are challenging the current status quo, if you will, in relation to how police nosy through your phone when they have it effectively. Maybe that's a bit cheeky me saying that, but that is the position. So there's ongoing litigation around that, and it's a very unique case, and we're hopefully going to get judgment relatively soon.
Well, it's clear that having experience of working within that area, you can pick out instances where those who do not work would take it for granted that, you know, criminal law is, as you said, it's just representing somebody who's subject to investigation, and that's really where it's at. But just from you describing some of those cases there are so many elements that could potentially go unchallenged unless, you know, as you said, people bringing those cases to you. I mean, you have to commend their bravery for doing that, which you do, but also to have somebody who can say, well, yeah, that's not, you know, that's something that can...
Yeah, and I think that goes back to the training that I had received in my firm where I had worked. It was a leading human rights law firm, and it was instilled in us as, you know, young solicitors, apprentices, that really we should not just be seeing the case that is before you, but to look in the wider landscape of how you can assist and help your client. And I suppose that is something that I have tried to instill within my current, you know, my own business, and it's something that I've had solid foundations in that previously. I suppose one final case that I would mention on is an ongoing inquest. It is the representation of the family of the late Daniel McConville. Daniel tragically passed away in McGabbery in 2018. And there is an ongoing investigation being conducted by the prisoner ombudsman, and we hope to have a report from Leslie Carroll in the near future. And there is an inquest scheduled for March of next year. And that case really touches again on prisoner rights, and he had passed away tragically in prison as a remand prisoner. And it really interplays between his access to welfare services and really again how prisoners who have mental health issues and problems and how they're being treated within the custody setting, because there have been a number of reports, you know, that are, you know, in the public domain now that illustrate a systemic deficit, we would say, in relation to the treatment of prisoners and the provision of proper and adequate mental health services. So that's another case that I am involved in, high profile in nature, but again, a very important case, because it's really to examine the circumstances surrounding Daniel's passing and to commend, you know, Daniel's family and the advocacy and the work that they do in their own right for prisoner rights, and particularly Daniel's father, who would be a staunch supporter of prisoners' rights within prisons, and again a difficult case, but hopefully via the use of the coronial process inquest that we will get to really what happened in his tragic passing.
And will that go on for some time, or is that
that case is listed for March, and it, as it currently stands, we're hoping 2 weeks, but it could run longer, and again we're given consideration to other legal mechanisms that we can deploy here to try and uncover what happened in relation to his passing. Again, a hugely emotional case, a very difficult case, but at the same time, as lawyers, we have to be alive to the legal issues and be alive to potential challenges that should be taken to try and get the four corners of what happened in that particular case.
Well, that just leads me into my next question that I was going to ask you. With these, you know, intense cases, you know, not only those that are high profile, but those cases that you're working with people on a very personal level on matters that really impact them. And I mean, the toll that case of Daniel McConville will take on his family is, you know, incredible. How do you, I suppose, and we've asked other guests this as well that work in similar areas, do you separate yourself from the case? I mean, you've mentioned there, you know, it's your job, you know, to identify areas that are up for challenge and, you know, to provide that professional service. But you're a human at the end of the day. You're clearly very passionate about your clients. How do you balance that, or do you?
I suppose, to be very candid about it, though, but it's difficult. It can be difficult because you're dealing, as you've said, sir, very traumatic and personal circumstances. But I think what you have to remember at your heart of it is that you're a solicitor employed look after your client to the very best of your ability and do the best by them. Is it difficult at times to detach yourself from the obvious emotions of a case, and you're dealing with families at their best but very often at their worst as well? And you wouldn't be human if it didn't affect you ways. But I try to, and I would give advice to anybody, to try and draw a line between, not letting the case affect you too much.
Sure.
But I don't think I would be human in saying that they don't. And I think sometimes that helps, because if you're personally invested in the case and you're personally committed to the case and you feel, a sense of loyalty to your client and to the case in itself, I think that forces you and strives you on more to assist and represent your client to the very best of your ability. But again, to answer your question, it's can be difficult.
Yeah.
But I'm honest about that. But at the same time, you have to make space for yourself and the people around you.
Yeah, you're so right. And just on that, I mean, you've set up your firm in quite a... When have we not had a tumultuous time in politics and in our environment here over the past number of years? But particularly now, I mean, with the current British government, in the sense that, they have launched quite a few scathing attacks on the legal profession over a number of years, and I don't see that going away anytime soon. I mean, lawyers have become scapegoats for their field policies time and time again. But your work involves, the mechanism of judicial review, which was attacked, relying on human rights instruments, which was attacked. There's some kind of rollback, essentially, in respect of a lot of what they had said. But how important do you feel it is for lawyers like yourself, solicitors, barristers, anybody championing, people who need a voice and need representation is, and how do you correlate that with what the government, I suppose, in terms of, attacking the rule of law, which is what we all stand to uphold? Yeah,
I think, and it is something that has been covered quite widely in the media recently, the commentary, the scandalous commentary, in my view, by the government against lawyers. And I was looking at this recently, that the former Home Secretary had described quite actually this podcast, lefty activist lawyers, and the other comments by the former Prime Minister, Mr. Johnson, around lawyers frustrating deportations of clients. And equally, you had members of Parliament using the blanket policy of parliamentary privilege to name and shame lawyers who represent maybe unfavourable people within the wider UK. I think, quite frankly, that's scandalous. And I think it's a damning indictment on the government, and in my view, to try and oust lawyers who use the law to represent their clients to the best of their ability. And I think it was Rosemary Nelson had said many, many years ago, if you do not defend human rights lawyers, who will defend human rights? And I think that was a very apt phrase by a lady who championed the cause in her own right. But the government's attempt to shut down not just the use of judicial review and human rights within England and Wales, but if you look at the attempt in relation to the shutdown on the legacy conflict situation here in our own jurisdiction, again, that is an attempt, in my view, by the government to curtail the rights and freedoms of members of the public. And I think that sometimes the government, when they're using phraseology, and discrediting lawyers, I think they should remember that the rights that we deploy to help and assist our clients aren't just for criminals, aren't just for clients in immigration spheres. It is clients, for example, a lady who was let down by the police in a field investigation, domestic violence. Human rights come into play in that in relation to your family rights, and equally the right to education. All of those factors, human rights permeate throughout all of that. But again, the government pick and choose their narrative of what they want to peddle to the media. And I find, frankly, comments by the government against lawyers are unhelpful in the 21st century, when again we are being entrusted by clients to do a job, but the government, may that be via legal aid cuts, delayment in payments for legal aid, which gives rise to Article 6 issues and convention rights, that they use all the tactics that they possibly can, and then we see it, as I've alluded to, the government using a legislative basis to shut down investigations in relation to horrific crimes in Northern Ireland, and effectively trying to pull the shutters down on the police ombudsman and the legacy investigation branch and all of that. And I think that very often the media look elsewhere throughout the world for attempts by governments to effectively curtail democracy and shut it down. But we need to look closer to home.
Exactly. You're so right. And just, I mean, the attacks continue. You mentioned there activist lawyers and lefty lawyers, which is at the time that this podcast really started up. But that just leads us into, I suppose, the next question about activism and the law, I guess. And how important is that to you? All of our guests kind of have a different perspective on that. Do they go hand in hand? How do you see the two engaging?
I suppose, in my view, there are really two ways to answer it. Activism in the law, in the sense of, one, your client has instructed you or entrusted you with very often a hugely difficult case for them. Okay, and I've alluded to some of these cases, may have been a criminal context, historical abuse or otherwise. And I think, figuratively speaking, activism in the law can be, one, standing by your client. Because very often when the client comes to you, they have nobody else to turn to. May that be in a police station or otherwise. And when your client entrusts you with their case, and obviously you have to advise them of the merits of a case and how to progress it and the rights and the wrongs of it. But again, standing by your client. Don't be afraid to stand by your client when things are difficult, because I know from experience sometimes you can be the shoulder to cry on. You can be the person to say, thanks very much, or you build a relationship. But standing by your client through thick and thin, difficult times, is in one sense activism in the law, because you are a lawyer, and standing by your client can be activism in itself. And maybe that might sound maybe a wee bit cheesy, but I wouldn't shy away from that, because if you look through decades of what went on in this jurisdiction, you had certain people that stood out for standing up for rights for clients, and that in itself is activism. And again, giving your client 110% in everything that you do for them. And the second way, in my view, in terms of activism in the law, because they do go hand in hand, is as a lawyer, as a solicitor or barrister or any other paralegal or legal executive, is being alive to the legal mechanisms that are open to you to challenge decisions, to help your client. Very often lawyers, and there's no criticism, are curtailed or blinkered in their view of how they can challenge something. But as a lawyer, you can be an activism in the law by being alive to the legal mechanisms that you can deploy against the state in themselves. And again, that takes a number of different options or avenues. May it be by a bail application, may it be by way of litigation, may it be by way of judicial review, or attending a police station, whatever that may be. But again, it's being alive to, as a lawyer, the legal issues at play, the issues that you have to contend with, and really how you're going to challenge and appeal those decisions. And again, that goes hand in hand with standing by your client, being in their corner, figuratively speaking, if you will, but again, being alive to, because you're a solicitor instructed in the case, being alive to the legal mechanisms that you can use and deploy to stand up and really advance your client's position.
And just in terms of, getting to the position that you are now, listeners would be keen to hear some of your advice and tips. And one question that has come up recently, actually, from particularly graduates or students who, you've very candidly and openly shared, your journey into law. And, it all starts from your apprenticeship. But it's not easy for people who really want to get into this area, whether it's criminal, any kind of human rights, public interest law. The commentary that we get from people is everything's still focused in learning on commercial law, and that's where the money is, that's where the funding is, that's where you get your contracts paid for, whether it's north or south. But people are really keen to hear how practically they can, get good experience and really, work in areas of human rights and public interest law. And I wonder, have you any advice or tips that you could share?
Yeah, and I remember years ago contemplating those questions myself, and I'm very candid about that, because I don't come from a legal dynasty or legal connections. I don't have any family members who are solicitors or barristers. So I remember contemplating those questions. Well, how do I get into this? What am I actually going to do? And I think the first thing is, and maybe activism is the right word, but being proactive. And And I would advise anybody is start sooner rather than later.
Yeah.
In terms of, trying to get the experience. And you have to be proactive in your approach in terms of contacting firms. And let's be level about this. You may not get paid for your work experience, okay? But you have to take the long-term view of, that'll go down in my CV. I was in that firm for a week doing work experience. And it's really about being proactive and knocking those doors, if you will. And I'm not trying to oversimplify it. But at the same time, you and yourself have to be proactive as a student to say, well, I want a long-term view to be a solicitor. This is the area that I want to practice in. So you need to be an activist or be proactive in that regard and start rapping doors and getting into those firms. I appreciate the sentiment, and it's something I've grappled with around the big commercial firms and the lovely shiny lights of how it looks. And again, I have a lot of friends who practice within the commercial world. Would I want to do that job? No, not for me. And I know that. But at the same time, get the experience of doing some commercial work as well, because at least you know then once you've done it, it's not for me. But again, the commercial firms are more geared up and tooled up for training contracts and vacation schemes and all of that. I think that our criminal firms and our personal injury firms ultimately in the future will go that way as well. I think there will be an evolution of how we recruit within law firms who aren't commercial in many senses. But my advice would be just be as proactive as you possibly can. And again, don't be afraid of rapping the doors and sending the emails and the CVs. Now, you may never get a reply, but ultimately you may have somebody who will. And who will bring you in, and like I was, okay, and I've been there. I'm quite upfront about that, and I was very grateful for the opportunity that I got. And in those views, you have to realise when there's an opportunity in front of you to grab with both hands.
Excellent, yeah. I mean, there is an element of luck to it. Yeah. But do you think that colleges and law faculties, should perhaps place more of an emphasis on these areas of law? I mean, going way back when, decades ago, they formed maybe a module here and there. There was no real emphasis on that as a career path or a career journey. I do know we've had guests on now that things have changed somewhat in this whole revision of clinical legal education, where it's more of a hands-on approach, going out and working with solicitors. Can the institutions do more when it comes to their students, do you think, Owen?
Yeah, absolutely. I would agree with you about that, Sarah. When I think back to my time at university, which really isn't that long ago, even then it was very much in the direction of commercial practice. It was the commercial firms that will come into university and done the guest talks, and it was very much geared towards a commercial outlook of where maybe the university wanted you to go. I don't accept that view. I really don't. I think that universities and even schools should be looking at the bigger picture, that not everybody has to go in and be a commercial practitioner, and it would do no harm to invite other firms, not just within the human rights context, but within other faculties of law as well, because it can't be a one-sided argument. You have to be collective in your approach. So I think that's important, yes, quite rightly, that universities do play their part in this process, and again, don't be blinkered to really the wider landscape that is at play. Excellent
advice, and a real insightful discussion there about your journey. You've been very candid and very generous with your time and sharing all of that with us. So I'd like to really thank you again.
Thank you very
for
much.
Joining me. And it's so exciting to hear about your new firm.
Great
and we wish you the best of luck with it. You're fresh and new, and you've lots of exciting plans ahead, which is fantastic. So thanks for joining us here.
Thank you very much, and thank you for having me
in the studio. No problem, Owen. Thank you.
Thank you.
This podcast was recorded in Granite Podcast Studio. Interested in starting up your own podcast but don't know how? Granite Podcast Studio can help. Record your podcast in our state-of-the-art studio, which is based in the heart of Newry City. Our studio has cutting-edge and user-friendly technology and can seat up to 4 people. We also provide an editing service for our team, using your guidance and editing notes to provide you with a flawless finished product, leaving your listeners wanting more. For more information on how you can get started, visit www.granitepodcaststudio.com.